next I'm going to turn to arbitration agreements, and this is really I've got here. This is an extremely important document to have in your personnel file. There's a lot of advantages, and as well as there's some disadvantages to using arbitration agreements in the employment setting. My advice generally is that I'm going to recommend an arbitration agreement. I find that there's more advantages to doing so than there are disadvantages. And one of the biggest advantages is that it protects your business against class action lawsuits. The arbitration agreement will contain an express waiver of class action lawsuits. Unfortunately, it does not protect the business against a PAGA case. The current state of the law is that employees cannot waive PAGA claims. So if you have an arbitration agreement and with a valid class action waiver and you get sued for class action, your attorney will be able to have that class action dismissed. I also find as an advantage that many times there's plaintiffs' counsels out there that they have no interest whatsoever in going to arbitration. They only want to deal with court cases. So they may have made a labor code records request pre-filing. And if they see an arbitration agreement in your response, many of them just may say, you know what, I'm going to pass on this one, and I'm not going to take on this class action case. And, a question I'm asked very often by smaller employers is, Ann, do I really need an arbitration agreement? I only have 50 employees. At the 50 employee mark, you really need to seriously consider rolling out an arbitration agreement. With a class action, the plaintiff can go back 4 years claiming damages. So it's no longer just 50 employees, and it's not just 50 current employees. It's all your hourly employees, former and current, going back 4 years. So if you think about potentially with all that alleged unpaid wages and penalties and taxes and attorney's fees, that can be a devastating event for a small business. Discovery is also typically streamlined in arbitration, unlike in a court case where it can be quite protracted. So this impacts the cost. And I believe that in most instances, arbitration is going to be concluded much faster than in a court case. Our court system is so backed up presently, and there's repeated continuances all the time. So it can take years and years in the court system versus usually my experience is that it's done in a year or less when you're in arbitration. So some other advantages here that for using arbitration is it typically is less expensive than trying a jury case. You also, there is no entitlement or right to a jury in arbitration. So that's beneficial because it takes away the risk of these unpredictable jury awards or having a runaway jury who may feel very sympathetic to a plaintiff and antagonistic toward the employer. And, the research that I've done is that, arbitration awards do tend to be smaller than if a similar case tried in case. And, the arbitrators, the conventional wisdom is that they're not going to allow their emotions to control their awards. They're going to apply the law and the facts of the case. And so that's avoids this risk of unknown, unpredictable awards. Also of importance is arbitrations are private, unlike a court case. Everything in court, you file your documents, the public can look at those documents. If there's any hearings in court, the courtroom is open to the public, including the trial. On the other hand, everything about the arbitration proceeding is private. It's behind closed doors, and there's no public access. So that can be beneficial to avoid unwanted publicity. Disadvantages of arbitration include that the employer is going to be responsible for the costs of the arbitrator and any other unique arbitration costs that you would not have in court. This can be quite expensive. And there's also a very limited review. So if you have an unfavorable arbitration award, it's more than very limited grounds upon which you can attack it, and it's most likely going to be found to be binding upon you. So the best practices for arbitration agreements, and I'm going to try and go through this as quickly as I possibly can, have it in a standalone document rather than inside your handbook. I mean, if you have your arbitration agreement within your handbook, those still can be enforceable, but for many reasons, it's much preferred to have this as a separate document. Make sure both parties have signed. You'd be surprised that sometimes I'll see that the employer representative hasn't signed the agreement, though the employee has. In that situation, I've had the employee argue that there's no contract at all. You have to have both parties to a contract sign it. If you have a large percentage of non-English speaking employees, translate that agreement. I see all the time challenges to enforcing arbitration agreements by non-English workers. It's an easy fix. Translate that document. Otherwise, the employee is going to be arguing, I have very limited knowledge of English verbally, and I hardly read English at all. I didn't know what I was signing. I didn't understand it. So translate those arbitration agreements. It's well worth the cost in light of the risks of litigation that you have. And, we talked about everybody should be signing the document. Electronic signatures are perfectly acceptable. And in many times that make a lot of sense. It's so much easier to access everything online. It's much faster to access everything online. But you want to make sure that your provider has a audit trail of the electronic signature on that arbitration agreement so that you can use that audit trail to authenticate the document in court. We get a lot of challenges in court in response to motions to compel arbitration, where someone may say, I did not click, that's not my signature there. I wasn't the one who did that. Somebody else did that for me. Make arbitration agreements voluntary. Currently under the law, you can make them mandatory, but we recommend against that, and that may not always be the law. So the consequences of this is that you may have some employees who just don't sign the agreement, and that's what it's going to be. When I'm arguing a motion to compel arbitration in court, I find that if that's the case, I have evidence that, judge, there's plenty of times when other employees have not signed it. So that evidence is the voluntary nature of this agreement. And I think that that's powerful evidence in support of a motion to compel arbitration. And if employees ask for a copy, absolutely give them a copy of the agreement. At any time during the onboarding process, your hiring manager should be trained to be able to answer any questions about the arbitration agreement, as well as any other of the new hire documents. But training your supervisors and your HR people about these agreements is really, really critical. Make sure that after the new hire documents have completed, those hiring managers know that they need to go through all of them, including the arbitration agreements, and make sure that they are signed. If they're not signed, they need to go back to the employee and follow up to make sure that you get everything signed. As far as processing and storing and retrieval of your arbitration agreements, make sure they're secure. have that audit trail if you're doing electronic signatures. Make sure they're accessible in a place where you can easily access them. If you're involved in a litigation, your defense counsel may need to get those documents very, very quickly. And once you are in arbitration, it is very important that you timely pay the arbitration fees. The consequences, if you don't pay those arbitration fees, are pretty significant. You're going to be back in court. So you get an invoice for a deposit for your arbitrator's fees for $90,000 that hasn't, and it's really in advance. You've got 30 days to pay that. If you don't pay that, and then you're back in court, if the original court case had class allegations, that class action is now going to be able to proceed. If you had paid the fees in the proceeding in arbitration, there would be no class action at all. And lastly, it's very important that you have your arbitration agreed on a regular basis. Have your arbitration reviewed on a regular basis by counsel. You need to make sure you've got the right language. The laws change constantly in this area, and you want competent employment counsel drafting this arbitration agreement. There's too much at stake not to have it regularly reviewed by somebody who knows what's needed to enforce those agreements. And I would say if you have an arbitration agreement right now that is 3 years old, it's time to get it renewed and updated to comply with the laws.